Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please.
Good morning, ladies and gentlemen. Before we begin argument, I'd like to invite everyone to join the panel in a moment of silence for our friend and former colleague, Judge Larry Silberman, who died on Sunday after more than 35 years of very distinguished service on this court. Thank you. Ms. Rothenberg, please call the first case.
Case number 21-3002, United States of America versus Aurelio Cano Flores, also known as Yankee, also known as CEO at Balance. Ms. West for the appellant, Mr. Booth for the appellate.
Good morning, Ms. West, whenever you're ready.
Good morning, Your Honor. Buenos días. Soy Ana Oeste, la abogada por Cano Flores. Ojalá que pueda explicar este caso a ustedes completamente. Now imagine, if you would, Your Honors, that you were facing a life sentence in a country you have no familiarity with. You've never been to this country, the United States. And the only person between you and that life sentence is your lawyer. There's no one translating for you during your conversations with your lawyer. And you can't even pantomime or give hand signals to your lawyer because of the formality of the courtroom. And what we have here is a life sentence because of the age of Mr. Cano Flores when he was sentenced. More than 50 years old, and he got a 35-year sentence. That's life. What could be more obvious than a client having the right to communicate with his lawyer during trial? The Sixth Amendment demands that.
So he did not raise this issue on his direct appeal, did he?
No, Your Honor.
So on his 2255, he complains of several things. And I gather your position is essentially there was no discretion left for the district court. It had to appoint a translator for Mr. Flores at all times, regardless of what arrangements his lawyer may have had, or what arrangements he appeared to go along with throughout the trial and throughout his over 50 meetings with his counsel and his counsel's assistant. So my question at this point is, what has he pled in the way of prejudice? What defense was not raised? And it would it have made a difference? What witness was not interviewed and would it have made a difference? All those sorts of things. And I didn't see anything, and maybe I missed it, suggesting there was prejudice to to the appellant in the outcome of the trial. And maybe you could help me there.
Yes, Judge Rogers. First, with regard to your first issue, it's not our position that Mr. Cano Flores needed a court-certified translator throughout the whole time. I think that would have been easy for Mr. Gilbert to do, and I addressed that. But our position is that he needed someone to translate his communications with Mr. Gilbert during the course of the trial.
Well, Mr. Gilbert, in testifying, offered his explanation as to why he deemed it most important for him to pay attention to what was going on in the courtroom in terms of the witnesses who were appearing, as well as any instructions from the district court. And here, the district court credited that as an understandable and reasonable strategy, given the elaborate system that Mr. Gilbert had set up for communicating, and no indication now of actual prejudice to the outcome of the case. And that's why in my first question, I posed it as I thought you were either suggesting that the district court's findings about reasonable strategy and no prejudice were clearly erroneous, or abuse of discretion. And I thought, well, if that's the case, then what's left except to say that you are arguing that error was in failure to appoint him a translator.
No, Your Honor. What we say is that there is prejudice that was suffered because Mr. Cano Flores and his lawyer could not communicate during the course of the trial. And I agree with the court, what you just said, that the district court credited the fact that he wanted to pay attention during witness testimony. But I outlined in my brief the many times that trial lawyers often communicate with their clients before court, during the lunch hour, after court, or even on the weekends and evenings at the jail.
But
So
a contextual decision focused on specific prejudice to the defendant in the particular proceeding. It's not
yes, Your Honor.
a general rule that some lawyers do it in some circumstances.
I think on the appendix on page 18, there are specific notes that were taken during the trial on February the 19th of 2013, where comments from Mr. Cano clearly show that there were lies from the witnesses from the stand, and he wanted those lies corrected. And as
Attorney said he already knew that was his client's position.
well,
So
I think
he didn't have to discuss it during trial, that they planned on a strategy, given that Mr. Flores, Cano Flores, was of the view that certain witnesses were not telling the truth.
well, you have to have a pretrial plan before you go into trial, but how is it that everyone who practices law and tries cases knows that no trial goes as planned? I'm not saying the pretrial plan was wrong. I'm just saying that that plan changed when people testified about things that were not in the plan. For example, in the record, there's an example of somebody who...
We would have to find that the testimony given before the district court in this case, or actually the magistrate judge initially, was clearly erroneous, contradicted by the record. And I'm asking you to be very specific as to what was the prejudice here. I understand that the trial could have been conducted differently. And the district court here found that, first of all, it was error for the magistrate judge to presume prejudice. And secondly, that there were just vague assertions about prejudice.
Yes, Your Honor, I would point to just the fact of what I mentioned in the record, but also the fact that a witness lied. That is the prejudice. And the reason why that's prejudicial is because when a witness is lying on the stand, and there's no cross-examination to contest that lie, the jury is not going to see that that witness is in fact lying. And
well,
as this
I know of no such rule, okay, that whenever a witness on cross-examination is shown not to be conforming his or her evidence to some objective evidence, that necessarily there has to be a new trial. And I don't want to take up any more time here, but I think you know my concern that I'm not aware of the defendant's arguments here about specific prejudice.
Yes, Your Honor. We noted in our brief about the notes from Mr. Cano Flores that showed specific lies. One being in the letter from the jail, appendix page 297. He also has an OHO sign. And again, on page 279 of the appendix, the jurisdiction in the Estado Toluca, talking about jurisdiction, that would have gone to the agent of the DEA agent who testified about the wiretaps. All I'm saying is there's a specific prejudice here because as this court noted in United States versus Muhammad, a court that you're familiar with, Judge Rogers, in assessing prejudice, the ultimate question is whether the defendant has shown a reasonable probability that adequate investigation, and here it would be communication, would have enabled trial counsel to sow sufficient doubt about the witness's credibility to sway even one juror. And that's what our argument is. If Mr. Gilbert...
Argument, counsel, what I'm asking for is, where is the evidence to support it? And you're saying that, well, witnesses lied. Counsel testified he knew that. They prepared the strategy in that light. Maybe he should have done more, but your client hasn't made these specific arguments. That's what I'm trying to grip with, not that you can cite places in the record where your client was saying that this witness lied, that witness lied.
Well, the evidence, Your Honor, would be in the written notes between Mr. Cano Flores and his lawyer, and those notes are gone. Those notes were destroyed. And not only that, Mr. Gilbert's notes from the trial also gone and destroyed. So those communications that would have shown specific prejudice, what those lies were about, are gone, and we don't have the we don't have those to fall back on. And those are facts that we don't have in front of us to show what the specific prejudice was, other than the fact that the witness was in fact lying. I see my time is up.
Thank you. We'll give you a minute on rebuttal.
Thank you.
Let's hear from the government.
It please the court. Under Strickland, this court reviews counsel's performance deferentially. And under that standard, Cano's attorneys acted reasonably in their methods of communicating with Cano and in using Valencia as an interpreter. Even if counsel's performance was deficient, Cano was not prejudiced. As to communication, Strickland said, this is at page 688 of 466 US, that counsel actually has several duties in dealing with his clients. One is a duty to consult with the client, but he also has a duty to test the government's case. And that would include paying close attention to the testimony of the government's witnesses so you can prepare an effective cross-examination, especially in a case like this one, in which the defendant and the attorneys had agreed that the defense was going to be reasonable doubt. The defendant was not going to testify, and there was not going to be an affirmative defense. That means that attorney has a lot of latitude in balancing the various duties that he has. And client consultation is not an absolute duty. In Perry versus Leak, and in this court in McLaughlin at 164 Federal 3rd, 1, both those cases upheld reasonable restrictions on a counsel's right to consult with his client during the trial. Now, counsel's method of communication with Cano was reasonable in this case. And why? The defense had team, including Valencia, the interpreter, met with Cano 50 times before trial to discuss trial strategy, where they agreed to present the reasonable doubt defense. They also agreed that Cano would communicate with Gilbert during the trial by passing him notes. And here's what happened during the trial. When Cano passed the note to Gilbert, Gilbert would do one of either two things. He would either nod to Cano to show that he had received the note, but also in other circumstances, he would write something on the note and pass it back to Cano. And that's in Supplemental Appendix 134 and 135. As he explained, and that's also on pages 134 and 135, he could understand the notes that Cano passed to him because he had a conversational ability in Spanish. During a break in the trial, Gilbert would read Cano's notes, and that's at Supplemental Appendix 524 and 525. And then at the end of the day, Hughes, the second attorney, would read Cano's notes or his journals on her way back home. And although she did not understand Spanish, she explained, and this is at pages 711 and 712 of this supplemental appendix, that these notes were not literature. They basically were notes that describe names and numbers, like the amount of drugs or the amount of money. As the defense attorney stated, the further communication wasn't really necessary in this case because there were no breaking events that Cano had to say to his attorneys, other than to say that he thought that the government's lawyers were lying. But the defense already knew that. They had met with him 50 times before trial. They knew what the defense was going to be, and they knew that the government, they were going to test the government's case by showing that the witnesses were liars. And of course, the defense attorneys met with Cano at the jail 4 or 5 times during the 2-week trial, and Valencia met with him also, and she shuttled, using the word that the district court used, shuttled notes back and forth to the attorneys. As to Valencia, she was an effective interpreter. The district court's finding that she made no substantive errors in translation is not a clearly erroneous finding. Even if there was an error in this case, Cano was not prejudiced. The test for prejudice in this context is whether he's shown a reasonable probability the result of the trial would have been different under Strickland. As to the notes, Gilbert testified that all they said essentially was that Cano thought that the witnesses were liars, but they already knew that. And as there's a claim here about Cano wanted to impeach a witness with respect to a roaming claim, on direct appeal, this court stated that the phone was sometimes in roaming mode. That's at 796 Federal 3rd at 86. And the calls were properly admitted whether the phone was in roaming mode or not, because as this court found, the calls were heard at a listening post in the U.S. The presumption of prejudice test doesn't apply here. That only applies when there's been a complete denial of counsel, where counsel has entirely failed to challenge the government's case, or whether there's a conflict of interest by counsel. None of those situations exist here. So unless there are any further questions, we would ask this court to affirm.
Randolph, Judge Rogers, thank you.
I understand, Judge Rogers, that you want specific examples of how this prejudice Mr. Cano Flores, and then the result of the case would have been different.
That's what the law requires.
Yes, Your Honor, I understand. The government just stood up and said, and also said in their brief, that Mr. Gilbert communicated with Mr. Cano Flores with a nod, and that Mr. Gilbert, in fact, could understand those notes. We disagree with that. There's no evidence that Mr. Gilbert could understand those notes because we don't have those notes and could not have challenged that. He testified, Mr. Gilbert did, that he could not communicate any substantive issue with Mr. Cano Flores, such as, for example, the roaming. That would have been a substantive issue that he could have talked about.
Why?
Because
we said on direct review that the communications were properly intercepted by agents in Texas.
That's correct, Your Honor. That's what you held on appeal. But that could have been challenged.
Why would it matter?
It would matter because it could have been challenged. The agent could have been impeached with evidence that, in fact, the phone was not on roaming. And that's something that Cano Flores in the record clearly tried to talk to his lawyer about, but was never able to talk to him.
Thank you.
Finally, I'd like to say, Your Honor.
Just briefly, please.
I'm sorry, sir?
Just briefly.
Yes. We believe that presumption in this case does apply and that the court's previous cases, Muhammad and Bell, show that presumption would apply in this case. Thank you.
Thank you. The case is submitted.
Case number 21-7125, Larry Elliott Clayman, individually appellant versus Thomas J. Fitton, individually et al. Mr. Clayman for the appellant, Mr. Driscoll for the appellate.
Good morning, Your Honors. I asked for leave to remove my mask. I took a test on Friday. I traveled here over the weekend, and I did not get the result until yesterday, and I'm negative.
And you're negative?
Yes.
All right.
Thank you very much. May it please the court. Pleasure to appear in front of you, all three. This is a case involving defamation. The statement at issue is that he, Klayman, yours truly, was ousted at Judicial Watch, asked Tom Fitton why he left. He left because of a sexual harassment complaint. This was allegedly published as pled in the complaint by Tom Fitton of Judicial Watch to Roger Stone, who then republished it on InfoWars. The law is clear that it's sufficient to just have one publication to one person. Here we had two. In fact, the law of defamation in a district says it simply must be published to a third party. That's Competitive Enter Institute versus Mann, 180 Atlantic 3rd, 1213, 1240 DC 2016, as well as the restatement of torts. It is enough that it is communicated to a single individual other than the one defamed. Here you have two publications here. And we also allege in the complaint that there was a surrogate publication. Stone was publishing it on behalf of Fitton.
What's the basis for your allegation that Fitton was the source of Stone's statement?
It says this was the publication, ask Tom Fitton. So obviously he got it from Tom Fitton.
How do we know that? I mean, this is about the circumstances under which he left Judicial Watch, and that had been the subject of a very public trial that had been ongoing for a decade. So
it has never been proven that I sexually harassed the office manager. I categorically deny that. But the bottom line here, Your Honor, is if it's plausible, it must proceed under Rule 9 and 8.
Do you deny that you physically assaulted your wife?
This has nothing to do with this case, and I do deny that vehemently. I deny it vehemently.
The jury found otherwise in the case.
The jury never made such a finding, Your Honor. The jury never made such a finding. One of the problems that we've had here, this is a third.
Why did the jury then award Judicial Watch $2.some million against you?
That's still being challenged, Your Honor, but the fact is that there was prejudice because that came in. It never should have come in. I left voluntarily. There was a severance agreement. It said I left voluntarily. I was praised. Parole evidence rule should never have allowed it in.
But the point here is that, and I think this is what Judge Katsas was asking you about, is that this was spread all over the newspaper a year before Roger Stone made the statement you're complaining about. All this information, the jury verdict, the evidence that came in, and so on. So it seems to me that your submission that the only way that Stone could have known this is from Fitton, it is belied by the fact that it was a public trial.
First of all, Your Honor, you're getting way beyond this case. Okay, you have been prejudiced yourself here
for third parties and other sources. I'm not saying you're a prejudiced person, but you've been prejudiced. This case, there's no claim of res judicata here.
Why have I been prejudiced? What do you're making an accusation?
I'm saying not.
Back it up.
I'm not saying that you have been prejudiced as a person. I'm saying that the things that have been out there in the alleged media, and wasn't even out in the media, Your Honor. You have to go back and look at that.
You think because I read an opinion of our court that prejudiced me?
The opinion did not say that. It did not say that, Your Honor. It's never been found that I sexually harassed the office manager.
Don't interrupt me when I'm trying to interrupt you.
Do I have equal rights?
The opinion said that the big issue before the jury was whether you left Judicial Watch voluntarily. The opinion said that.
The opinion did not say anything about sexually harassing the office manager. Your Honor, I asked respectfully that you go back and read that. It did not say that. In any event,
well, neither did Roger Stone.
I'm entitled to plead in my complaint, to make a claim in my complaint. There's no defense of res judicata, collateral estoppel, or anything. Under Twombly, as long as it's plausible, the matter has to proceed. And here's what Twombly said. The complaint must contain enough factual matter taken as true to suggest, this was dealing with an agreement in restraint of trade, an antitrust case, asking for plausible grounds to infer an agreement does not impose a probability requirement at the pleading stage and simply calls for enough facts to raise a reasonable expectation that discovery will provide evidence of an illegal agreement. You must only plead enough to cause a right of relief above the speculative level. Given the defendant fair notice of what the claim was is the grounds upon which it rests. It only must be plausible, Your Honor. Plaintiff need not allege specific facts. The facts alleged must be accepted as true, as the facts need only give defendant fair notice of what the claim and the grounds upon which it rests. Erickson versus Parsons, 551 U.S. 8993. And then Twombly adds, going back to Twombly, a well-pled complaint may proceed even if it strikes a savvy judge that actual proof of those facts is improbable and that a recovery is very remote and unlikely. I pled what needed to be pled, Your Honor. And I don't mean any disrespect to you, but what has occurred here over the years, and I have a defamation judgment against Judicial Watch going back to Miami in 2014, has prejudiced me. I'm not saying you're a prejudiced person, not at all. I've had issues with judges in this court, particularly Judge Kelly. And I sometimes get the impression that the judges in this court circle the wagon. There was no such finding that I sexually harassed the office manager. Even Judicial Watch didn't make that at that trial. There was no finding that I in any way abused my wife. I'm desirous of equal rights here. There's no finding to that effect. And I pled what needed to be pled in this complaint. The complaint must proceed. You're here with an oath of office to follow the law. The law does not enter into what you may think a jury found in another case, because there's no such jury finding. There are no specific jury interrogatories. And if you want to get back into that case, I don't even know what was given to the jury in terms of the written instructions. But there's no such finding there. I categorically deny that. I'm entitled to equal rights here, Your Honor. And the fact that I've been smeared here, and there's enough here. There's enough here.
The entire subject came up because you said that the only way that Roger Stone could have possibly come up with the idea that you left Judicial Watch, you were ousted. The only way that he could possibly have known that is through Mr. Fitton. But the relevance of the prior decision in this court and the jury trial was that there was another way. Because of your earlier trial, that was the issue according to the opinion.
I wasn't trying that, Your Honor. That wasn't an allegation in the case. It was brought in trial. Judge Catelli let it in out of the blue. It was prejudicial. And even the statement that came in wasn't that I had sexually harassed the office manager. That was not the statement that came in. And if you're looking at the actual publication here, Clayman was ousted at Judicial Watch. Ask Tom Fitton. It's more than plausible that Fitton said that to Stone, and that's enough for a defamation case. You are bound under Rule 9 and 8 to allow this to proceed, and you're bound under Twomey. You don't get to decide a case before it goes to discovery and goes to a jury. You don't get to do that. That's not a judge's role. And I'm sorry if I'm being emphatic, but this is exactly what's been happening in a lot of different cases, not just with regard to me, but every judge is taking cases away from discovery and from jury, them making a decision which the Constitution gives a party a right to at least plead in a complaint and take discovery. And I would like to get into telephone records. I want to talk to other people here as to what was said. I have a right to do that. That's my constitutional right. And I'm sorry if I'm upset, but frankly, to rule otherwise is a severe injustice.
Judge Rogers, any questions?
No.
Thank you. Anything else?
No, I thought maybe Judge Rogers wanted to say something.
No, we're all
right, thank you.
Mr. Driscoll, we'll hear from you.
Good morning, Your Honors. May it please the court, Rich Driscoll on behalf of the appellees Thomas Fitton, James Peterson, Paul Orphanides, and Christopher Farrell. Neither party before the court this morning is arguing for a change in the law. The issue before the court is whether the law was properly applied in the lower court. I think the court needs only look at page 9 of the joint appendix in paragraph 12 to read the allegation regarding who made the alleged defamatory statement, which reads, on information and belief, the defamatory statement alleged herein were made by defendant Peterson and or defendant Fitton at the direction of or directly by the other defendants to Stone.
Twombly and Iqbal didn't eliminate pleading on information and belief, right?
No, sir, they did not.
So why isn't, for that kind of allegation, why isn't it enough for him just to say on information and belief, Fitton made the statement? I mean, right?
Under the law of this jurisdiction, and I believe the case Franklin v. Pepco Holdings, the standard of allegation for establishing a defamatory statement is that the plaintiff must allege the time, the place, the content, the speaker, and the listener. And here, that may have been done with regard to the statement made by Roger Stone, but it is not done with regard to any of the defendants. And in fact, this court agreed that at least with regard to appellants Peterson, Orphanides, and Farrell, that is correct. There was no allegation. And in the complaint, the only distinction between the allegations against those three defendants and appellant Fitton is the allegation, ask Tom Fitton. So the question then becomes, does the phrase ask Tom Fitton push this case over the line from a possible claim to a plausible claim under Twombly and Iqbal?
I understand your argument that that inference is not a plausible one. I guess I'm asking whether you even need to make that inference. I mean, suppose you were suing Mr. Klayman and you alleged that he's a resident of Florida, and you don't say anything more, right? And he says, well, what's your basis? What's your basis for saying that? And your position would be you don't need it anymore. It's just a historic fact and you allege it.
Well, because...
And why isn't that, I mean, inferring a conspiracy, an antitrust conspiracy, which is Twombly, or inferring discrimination, which is Iqbal, seem a little bit different from just a historic fact that A made a statement to B.
Under the law of defamation in the District of Columbia, a blanket statement of A said this to B without more is insufficient, inadequate, and does not reach the level of plausibility. It's a possibility, but it's not plausible, because what you must know is who said the statement, okay? So let's assume he doesn't know exactly who said the statement. Let's assume it's one of the four appellees. How does he know it's one of the four appellees? In the complaint, there's not even an allegation with regard to three of the appellees. And the only specific factual allegation in the complaint is that Roger Stone said, ask Tom Fitton. Other than that, the complaint is completely rife with conclusions, not facts, conclusions. To say that the defendants acted in concert is a descriptive conclusion. It's not a fact. So you can't allege that without an underlying event, a fact, or an occurrence to support it. And here, the appellees are emphasizing that the complaint lacks those predicate facts on which to build the summary allegation that a defamatory statement was made. Here, we're dealing with pure speculation based on a historical animosity by Mr. Klayman against Mr. Fitton and others at Judicial Watch. It's when you look at the complaint and you read each paragraph through, the complaint really boils down to Roger Stone said this, and the only way he could know how to say that is if Tom Fitton told him. And even that predicate argument fails because Tom Fitton has admitted under oath in a deposition that that's not the reason Larry Klayman was forced out of Judicial Watch. And Mr. Klayman filed this same lawsuit in the Southern District of Florida, and it was dismissed by Judge Martinez, who found, we've quoted the language in our brief, Judge Martinez found that there was no tortious or wrongful conduct in Florida. And the law of Florida, the long-arm jurisdiction law of Florida, can encompass both an act in Florida or an act outside of Florida directed at Florida. So at least with regard to Florida, we know based on Judge Martinez's argument that there is no wrongful conduct here. But in order to reach that point, Mr. Klayman was allowed to depose Tom Fitton for 2 hours and ask these questions of him. He's not here before the court without having had an opportunity for discovery. He's deposed Roger Stone. He's deposed Thomas Fitton. He has nothing. And there's no reason why he should be given another opportunity to harass the defendants in this case. And that's the position that we argued in the lower court, and it was accepted by Judge Chutkan. And we believe that Judge Chutkan's decision is correct and should be affirmed.
Okay, Judge Rogers?
Oh, thank you.
Thank you.
Okay, thank you.
Your Honor, the law is clear that you just have to have a plausible claim. And when someone says, ask Tom Fitton, it's plausible. Specific date is likely in and about the time that Roger Stone republished the event. But even that is not required in terms of the eventual pleading. And you can look at the cases that state that. 220 U.S. District, DIST Lexus, 161295, 220 Huawei 525-024 at 8, wherein it says, and this is a case coming out of the Western District of Texas, for instance. Similarly, the Eastern District of Texas found the plaintiff had pled, quote, his defamation claim was sufficient particularity to put defendant on notice of the claim, even though the allegations relating to the defamation claim do not specify when these alleged statements were made or with regards to the letters to patients to whom they were specifically made. Also, you can look to the case of Cantu, C-A-N-T-U versus Guerra, 2021 U.S. PI District Lexus 119681 at 42 to 43, also Western District of Texas. We pled all that needed to be pled here, Your Honor. And we also stated, yes, that the defendants made these statements, and we pointed out that Fitton was the one who was, in fact, fingered, for lack of a better word, by Roger Stone for having made it. And that's enough to go forward. In terms of discovery, this was a misstatement by Mr. Driscoll, regrettably, is that the case was dismissed in Florida on personal jurisdiction. The judge never got to the merits. And to have Fitton simply deny it, that's not discovery. I get to take a look at telephone records, I get to talk to other people, I get to see text messages and other things like that. Obviously, people are going to deny things. So that's not demonstrative. So, Your Honor, we ask that you allow the case to proceed forward respectfully to everybody, including Judge Randolph. You are required to do that under Twomby. Thank you.
Thank you. The case is submitted.
Case number 21-1159, State of Arizona et al. Petitioners versus Environmental Protection Agency, Michael S. Regan, Administrator. Mr. Ensign for the petitioners, Ms. Chen for the respondents.
Good morning. Is it Ensign?
It is, Your Honor.
Welcome. Please proceed.
May it please the court, Drew Ensign, Arizona Deputy Solicitor General for the petitioner state. I'd like to reserve about 4 minutes for rebuttal. The delay rule here is unlawful for 3 reasons. First, the delay rule's entire purpose is to reconsider the prior rule. For reconsideration, this court has been perfectly clear that the mere fact of reconsideration is not a valid basis.
Before you get too deep into the merits, can we talk about standing?
Absolutely.
Your complaint is that this rule gives the states a greater degree of regulatory flexibility to meet the deadline. And we've said time and again that that kind of injury doesn't count under Article 3. Greater flexibility, waiving a rule that would otherwise constrain the challenger's options, that's what we have here.
Your Honor, I do believe we have standing here for 3 reasons. I'll kind of skip ahead to the option theory is the one that the EPA specifically advanced in Air Alliance, and this court squarely rejected it. That's the issue, and that was also a delay case. That there, it was absolutely clear that New York always could have adopted the challenge rule itself, your challenge standard itself, more quickly, but that did not defeat standing there.
I mean, that's your best case, but it's a different regulatory system. I mean, here you're locked in. You're locked into all of your obligations as primacy states, right? You're going to have to enforce the federal standard either way.
I think that's correct.
And the only question, you haven't said, gosh, we would otherwise opt out of primacy and there might be injuries flowing from that. So we take that as a given. We take as a given that federal standard is what it is. You're going to have to enforce it. And the only question is when you promulgate your conforming regs to make your own standards equal to or greater than the federal standard.
So, Your Honor, I think all of this goes to compliance costs. So I'd like to go through that first and then kind of circle back on the others. We don't think the fact that we're primacy states or direct regulators here is a distinction with airlines that hold weight. If anything, it means that we have less choice than New York did there. New York was essentially much less bound and had greater optionality, whereas as primacy states, we effectively have less choice. And the subject matter also makes it such that as a practical matter, we have less choice as well. No, we're not going to choose to not run drinking water systems. That would be catastrophic. But turning to the cost, even if you accepted EPA's premise of this choice argument, which this court rejected in Airlines, it still would only account for part of the state's harms and not all of them. And that's because even if the states adopted this option to adopt these standards earlier, other states would not need to, and other states would in fact take the option that EPA is offering them to delay that. EPA has calculated that that will cause permanent brain injury in children to occur. They have not disputed our evidentiary submissions that as a result, there will be increased Medicaid and Medicare expenditures, and many of those children will move to petitioner states. Indeed, Arizona and Texas.
And this 2017, the January, 2021 rule was so underprotected. But I mean, there's a challenge to that rule. It's brought by people you would expect to be bringing a challenge to that kind of rule, which are the environmental groups, and none of the states are involved in that.
That's correct, Your Honor, but I don't think that has any legal significance. I mean, here we have EPA itself has quantified.
No, but I mean, it makes it seem a little bit rich, your standing theory that kids all over the country will be getting brain damage and moving into your states, and you'll have Medicare costs, Medicaid costs, whatever. When there's a direct challenge to the rule and none of the states even bothered to join it.
Your Honor, ultimately, I don't think it bears on the standing analysis. Here, what we're dealing with is a statistical certainty that these things will happen. The numbers are large, they're calculated by EPA themselves. They flow inexorably and are essentially not denied here. So regardless of how the other case, is proceeding, that doesn't affect our standing here as a legal matter. I think we also have standing on two other bases.
I don't know if I heard you correctly, but and I don't recall seeing this in the brief, but are you saying that even if you, and by you I mean the states that are parties, promulgated regulations that duplicated the ones that are being delayed by EPA, even if you did that, if the other states don't do it, then because of the interconnection of navigable waterways and so on and so forth, that you would still be subject to harm?
Not because of the navigable waterways, Your Honor, but rather because of navigation of people themselves. Arizona and Texas are two of the states that are most migrated to within the United States. And so if children incur these permanent brain injuries as a result of lead and water in other states, it's statistical certainty that many of them will move with their parents to both Arizona and Texas.
Oh, it's the individuals that would move, not the water.
Exactly, Your Honor.
Okay, because why? Because drinking water supplies are self-contained? Is that right?
For the most part, Your Honor. I'm sure there's some, there may be edge cases where that doesn't hold, but for the most part.
That's what I understood, but I wondered about the interplay between waters moving and pollution and so on and so forth. That's not part of your...
That's correct, Your Honor. Our standing theory is based on the movement of people and not the waters.
This is not a WOTUS case.
I do want to quickly highlight two other bases that we think standing exists. The first is this court has well-established doctrines that when someone is the regulated party or the object of the regulation at issue in the parlance of Lujan.
I mean that, but...
Your Honor, but...
Sure, but when a directly regulated party has the regulation lifted, that doesn't give it standing to challenge the lifting.
Your Honor, I think it might, and I think a case of this court that maybe bear on that is State National Bank versus Liu.
I'm sorry, which one?
State National Bank of Big Spring versus Liu. This is not cited in our briefs.
Is it in the briefs? I don't recall it.
It was not in our briefs. It's 795 F3rd 48. There, the regulated party was challenging the CFPB because of a recess appointment as well as its constitutional structure. This court said, as the object of regulation, you have standing to challenge that structure, even in the absence of any regulation. So there was not yet any regulation that you could figure out if it was more or less stringent or giving a more or less
On what theory, though? I assume on the theory that the CFPB would eventually do something to constrain the party bringing the challenge.
I think that's implicit, Your Honor, but I think that drives home the point that where we're the regulated party and you subject us to illegal regulations that we're ultimately going to have to comply with, that's a form of injury. If I could just quickly walk through our one other form of injury.
I mean, I think your second one is more colorable than your first one, but you can take whichever one you want.
A single state needs one theory.
All right, so one is, sure. So you've got your directly regulated party theory.
Yep.
You have your kids elsewhere will get sick and move into our state, and then we'll have to pay their medical bills theory.
Yes, Your Honor, and I'd add airlines rejects the optionality theory, at least in our view.
And then you have a third.
The third is, Your Honor, that we have compliance costs in the form of planning and familiarization costs.
The uncertainty.
Not just, yes, Your Honor. So before the delay rule, it's undisputed that we would only have to prepare for a single standard. That's the LCRR. There was nothing else to plan for. It's less costly to plan for one option. As a delay rule, here's what EPA itself said the state should now do. EPA recommends the states consider each of these possibilities, that was total repeal, no changes, and modifications, in their planning and resource allocation decision-making. So EPA itself is admitting that as a result of the delay rule, instead of planning for one standard, we now should be planning for multiple standards. And
They said a lot of things confirming the truism that they can always change the law to impose new requirements on you. But the final agency action under review is, as far as I can tell, one and only one thing, which is the order delaying the effective date of the January 2021 revisions, which are now in effect. Effective but not applicable. I forget the distinction. They are what they are. You know what they are. You plan for the T+3 years when you have to comply with them.
So, Your Honor, I guess a couple things about that. One, the EPA is not arguing mootness. It would have been judged at the time of our petition when it wasn't in effect. But more fundamentally, the delay rule is inextricably intertwined with the reconsideration itself. The two cannot be separated. Their EPA's explicit rationale for the delay rule, it's the reason they give. And so you can't parse the two of those. The delay rule is delay for reconsideration, and it's that reconsideration that causes us to incur additional
The reconsideration has run its course, and the amended standard has become effective.
It has, Your Honor. I mean, I think there is still uncertainty as a result of what they're doing here. And, mootness is now just a question of whether it's impossible to grant any relief. EPA has not even made any contention that that's not the case. By having some additional certainty, that would allow the states to plan more directly, because at least then, this issue would be resolved, as well as whatever is going to go forward.
How do we reduce uncertainty if we set aside this deadline and everything just moves back by 6 months? How does that address uncertainty? And they still have the authority that they asserted in December of 21, that they can ramp up the amended 2021 standards more in the future if they want to.
Your Honor, I think that ultimately EPA's understanding of how they can proceed is something that is causing us the uncertainty here, where they believe they can delay things solely for the purpose of reconsidering them, is something that has, led to this entire dispute. And
I'm sorry, Judge Rogers, I think I cut you off.
Well, I wanted to ask counsel, the series that you offer on standing, though, what are their limitations? As I understand it, even a rule in effect, as Judge Katsas has been pointing out to you, can be amended. The agency will often issue statements about we're considering whether or not we ought to amend this rule for following 5 reasons. That's uncertainty. And I don't understand how your theory provides any limitation such that any state at any time, as to any existing rule, can probably point to statements by high-ranking agency officials that maybe we ought to reconsider this for the following 5 reasons. Or you know very well, as Judge Katsas was pointing out to you in the beginning, the environmental groups have brought a challenge that's ongoing. So there's all this uncertainty in the world. And to the extent standing has some requirement of specificity and imminence, how does your theory, how is it compatible with those basic requirements of standing?
Your Honor, I will certainly admit that our injury regarding year 1 planning has weakened since this case was filed. Standing is, of course, judged the time that the petition for review was filed and where those year 1 compliance costs were very much live. I think the fact that the rule has now taken effect would be an issue of mootness, which which EPA has not seen fit to argue. And so that is something that they certainly could have presented and perhaps will now do, but that is not something that is in the briefs. So as to the current state of affairs, where this is now taking on more of a flavor of mootness than standing, I will admit that our self-evident standing and our proprietary Medicaid and special education costs are now more relevant in the posture here today than they were when the petition for review was filed. But of course, that's when standing should be assessed.
We've taken up all your time on standing. I'll give you a little bit of time on the merits, unless my colleagues have questions on the merits. I'll just ask you to keep it brief.
Thank you, Your Honor. I appreciate that. And again, Air Alliance makes clear the mere fact of reconsideration is not a basis for delaying a rule. EPA has repeatedly admitted that's exactly what it did. That squarely violates Air Alliance. And as to the discount rate, 3 versus 7% is utterly dispositive of quantified cost-benefit analysis here. EPA didn't even attempt to select one, let alone do so intelligibly, as this court's NRDC versus Harrington case requires, and therefore that violates the APA.
Judge Randolph, Judge Rogers, thank you.
Thank you, Your Honors.
And we'll give you rebuttal. Ms. Chen, good morning.
Good morning, and may it please the court. Sue Chen for the United States, and with me today is Leslie Darman from EPA's Office of General Counsel. EPA issued the delay rule with support from a broad range of stakeholders, including Petitioner Texas. After a short delay, the revision rule is now in effect, and EPA is working on a new rule to really strengthen the revision's protection. I'd like to first address standing and then answer any questions you may have on the merits. Petitioner is not standing to challenge the delay rule for 2 reasons. First, the delay rule, rather than create new obligations, offers primacy states and their water systems an extension. But what is more, petitioner's primacy status puts them in the position of having to either accept or reject that option. And that is because as primacy states, petitioners must adopt the revision rule, whether the delay rule exists or not. And so the costs of that adoption don't count for purposes of their standing. The question that the delay rule raises is what compliance date petitioners will write into their state regulations. And this is the point where they can act on EPA's offer. They can either accept that offer of the later October 2024 compliance date, or they can reject it and stick to the January 2024 date that came originally with the revision rule. And if they reject, no one in their jurisdictions gets the benefit of the compliance extension. Moreover, there is no evidence that rejecting EPA's offer, that writing in the word January as opposed to October, would somehow incur more costs for petitioners. So because petitioners can costlessly veto the delay, any delay-related injury would be self-inflicted. My second point on standing
Are
is that
you saying that, I'm having some difficulty understanding you because of the mask,
sorry,
but are you saying that, number one, that the effective date is already come and gone,
yes,
right? And that the difference between the original rule and the delay rule is that under the revision rule, it would be January 2024 when you had to comply.
that's right,
But now it's October 2024.
correct.
And that if there's harm, it has to be between January 2024 and October 2024, is that?
No, what I'm saying is petitioners, so the delay rule offers them the option of a later compliance date. And they have to either accept or reject that date. And they can pick whatever they want between January and October. And so to the extent they have any injuries relating to the delay, that would be because they picked the later October date.
Or sooner, right?
Or sooner. They can pick tomorrow for their compliance date if they wanted.
For compliance, you're talking.
For the water systems in their jurisdictions to comply with the revision. Yes, that is the only part of the revision rule that is, that changes thanks to the delay.
It's the effective date completely isolated from the substance of the underlying
Compliance.
compliance.
Yes.
Yeah, the compliance date.
Yeah.
Sorry.
Because the delay rule did not lift petitioner's obligation to adopt the revision rule. It did not change any other aspect of the revision, though they still have to adopt that rule. My second standing point is that the court should reject petitioner's belated argument that people moving from other states somehow hurts them. This is raised for the first time in the reply on page 12, and it is forfeited because it comes too late, especially since in our motion to dismiss at footnote 7, we noted that petitioners don't argue that other states' actions somehow harm them. And in their opposition to our motion, they didn't say anything on this subject. They didn't say anything in their opening brief, even though the court had ordered the parties to brief the issues in the motion to dismiss. And there's no good cause to excuse that belated argument because that theory that they presented in the reply fails to irrefutably show standing. And the main problem there is that they have offered no specific facts to show that any injury is imminent. There's a lot of speculation built in. One of which is that it's not clear that their future residents will be coming from water systems that would have to take any corrective action under the delay. So by corrective action, I mean replacing lead service lines, upgrading corrosion control treatment, and public education. And under the revision rule, water systems have to do those things only if sampling shows that their lead levels exceed certain thresholds. Well, in the revision rules economic analysis, EPA estimated that between 58 to 97% of community water systems would not exceed those thresholds. So they would not have to take any corrective action. And people moving from those water systems to petitioner states would not count for purposes of standing. And I realize that I think the court probably does not have a copy of the economic analysis because we weren't able to make this argument in our brief, and I'm happy to submit a link after argument to the court if that would be helpful. Even for water systems that would have to take corrective action under the delay rule, when they have to do it relative to when future residents will be moving to petitioner states matters. So under the revision rule, once a water system exceeds those thresholds, they don't have to take corrective action right away. Depending on their size and what their state regulators require, it could be a while before those corrective actions have to be actually implemented. And so for people who are moving to petitioner states before those corrective actions would have to take place without the delay, those people would also not count for purposes of standing. And really, one of the problems here is that petitioners have said nothing about this timing issue, let alone present specific facts. And so I think at best what they have alleged is the kind of someday injury that Supreme Court rejected in Lujan. And I think really at the end of the day, all that the delay rule does is, as you said, Judge Katsas, it offers petitioners the option of more time. They're free to reject it. There's really no dispute here for the court to get involved. I'm happy to answer any further questions you may have, including on the merits.
Judge Rogers?
No, thank you.
No.
Thank you. We understand.
Thank you very
your
much.
position.
Thank you, Your Honors. 4 quick points on rebuttal. First, EPA has never answered the state's argument under this court's doctrines that standing is self-evident when a regulated party is affected by regulations. They didn't answer in their brief, and they did not address it today. I realize standing is, of course, not a waivable issue, but they have offered no argument why that does not apply here.
What's your response on the theory about out-of-staters getting ill and moving in? What's your response to the government's forfeiture argument?
Your Honor, it's a response to their argument that because we have a choice, it doesn't cause us injury. But so it's a direct response to them. It's not waived because it's
you need a theory. You need an affirmative theory of standing.
That's
and
correct.
Their defenses are not waivable, but your affirmative theories are.
That's correct, Your Honor.
Okay, so let's assume, for the sake of argument, I don't buy your first argument that you're the regulated party, so you're done.
Yes, Your Honor.
You need another affirmative theory of standing, and the next one you offered up was this one about out-of-state kids getting sick and moving in, and I mean, it's either preserved or it's not, but if it's not preserved, it's a problem for you.
Your Honor, I agree that we needed to make it as an affirmative case, and I believe we have here. Our opening brief expressly raises that we will suffer injury, proprietary injuries, in the form of increased Medicaid costs and increased special education expenditures. In response to that argument, EPA waived that you have an option argument that this court squarely rejected in their alliance. But even if that had merit, our argument about movement of people is a response to their choice argument and demonstrates why that would only preclude some, but not all of our harms, leaving the states with some cognizable injury. So that movement of people is a direct response to EPA's defense that our proprietary costs don't count. And it's a reply to that argument as to why the the proprietary costs that we raised in our opening brief still hold. So that was an argument raised in our opening brief, and they do not in fact dispute the fact that we will incur these costs. They just argue they're not cognizable. Our argument to reply was a response to that argument, but it's all part of the original proprietary injury argument advanced in our opening brief.
Got it. Judge Rogers?
Nope.
Okay, thank you.
Thank you, Your
Case
Honor.
is submitted.